All right, guys, we've got the assignments of error that have been filed by Amber Heard and Johnny Depp. So it is time to talk about them. So the first thing that jumps out from these documents is simply the fact that we have 16 assignments of error from Amber Heard, 3 assignments of error from Johnny Depp. I think it was Scott Adams who said that if you want to be able to identify cognitive dissonance, look for when there are a million reasons for something as opposed to 1 or 2. Amber Heard's assignments of error tell us a lot, in my opinion, about what she's doing and what her strategy is. If you watched my last video on the appeal, you already know that there are certain types of errors that are strong in an appeal and certain types of errors that are quite weak. And so there can, of course, be different strategies, different priorities with what is ultimately chosen to be pursued. But most lawyers who are working on appeals are generally going to advise you, you need to prioritize your strong issues, and you need to simply make your peace with not throwing every possible thing at the wall that you think could stick. And part of the reason for that is because you have limited time and space to be able to make your arguments. Virginia does have a rule for appellants' briefs. They are limited to 50 pages or 12,300 words. So she's not going to have an infinite amount of time to be able to argue 16 different errors in her appeal. There's also some fairly specific details about what the briefs need to include content-wise. Those are spelled out in this particular Virginia rule. So you have to have your table of contents and authorities, table of authorities being the law that you're relying on, a brief statement of the nature of the case and the material proceedings in the trial court. So just an introduction basically to what this case is about and what the appeal is about. Under a heading entitled Assignments of Error, the brief must list clearly and concisely and without extraneous argument the specific errors in the rulings below or the issues on which the tribunal or court appealed from, failed to rule upon which the party intends to rely, or the specific case law that should be overturned, extended, modified, or reversed. So they have to restate the assignments of error in their opening briefs. This is all counting against their 50 pages and their 12,300 words, remember? They have to then go through the statement of the facts that they're going to need to rely on to be able to substantiate these assignments of errors, to be able to show, here is what happened, here's the context in which it happened, here are the facts that show us why it matters that this happened. The standard of review in the argument, basically your law, and then a short conclusion stating the precise relief sought. What exactly is it that you're asking the court to do? Are you asking them to give you a new trial? Are you asking them to reduce the damages? Are you asking them to throw the case out in its entirety? All of these things need to be in the brief. So my goal in laying this out is really to show that 50 pages, you can run out of that pretty quickly. So for practical purposes, 16 assignments of error, they are not going to fit in a normal sized brief, even under the best of circumstances. So if she actually does intend to raise all of these and actually argue them, and hasn't just put them in her designation of assignments of error in order to, I guess, preserve the ability to be able to raise them, or perhaps just to have them out in public that she has alleged that these things are errors. It's not going to happen. She's going to have to ask for permission from the Court of Appeals to file an overlength brief if she does intend to go down the road of all 16. So these requirements for the briefs give us a pretty practical reason for why it's generally not a good idea to throw 16 assignments of error at the Court of Appeals in your brief of appellant. But there are other considerations as well, and the obvious one is simply that it dilutes whatever good issue you may have to drown it in a whole bunch of bullshit that has no chance of winning. Something that I think people often have a hard time coming to grips with, certain types of litigants find very challenging to accept, is that there is no guarantee of a perfect trial. It is absolutely understood that the legal process, it is a human process. There are likely to be errors at some point in some fashion in that process. That's life. Nothing is usually ever perfect. So if you are going to call out every single little thing that looks like an error to you, regardless of whether there's any realistic prospect that it mattered in the big picture, it really just makes you look very petty and very unreasonable because your expectations are not in line with what the court system is going to be able to deliver for you. An example of this, in my opinion, was number 8, Amber Heard's assignment of error number 8. The trial court erred in sustaining an objection during the cross-examination of Mr. Depp to a question about the truth of one of the allegedly defamatory statements on the ground that it called for a legal conclusion. So a single objection to a single question during one witness's testimony during a 6-week trial is, according to Amber Heard, going to be a basis that could have changed everything, right? That was the dispositive moment, because that's the position that you have to be taking to justify raising this and arguing this is an error that warrants the court's attention because it probably affected the outcome of the trial. If it's just an error that happened that didn't affect the outcome of the trial, it doesn't matter. It doesn't belong in your appeal brief. So this is an example of just an assignment of error that is really, really misguided. If you had absolutely nothing else to argue, would you maybe rely on this one? Okay. But it doesn't really make it any more likely that you're going to win it. Just makes it a little bit more justifiable to raise it. So that's really the problem here, is that even if you have good issues, if you drown them in all this other crap that the court is going to have to wade through, they are going to lose their perspective on the strength of the issues that you do have. They're going to become skeptical of pretty much all of your arguments. An important detail to bear in mind as you look through these assignments of error is that these are not the reasons why she is arguing that the rulings were incorrect. These are merely identifying the rulings themselves. And so a common misconception that I've seen floating around is, for example, she's not raising First Amendment issues. That's not technically correct. The First Amendment issues would potentially be the reasons why she is arguing these rulings were incorrect. So, for example, this assignment of error number 13 that's dealing with her motion to strike, this is very likely where at least some of those First Amendment arguments are going to be incorporated as the reason why according to her, Judge Azcarate got that ruling wrong, because this is where those First Amendment issues were raised in the motion to strike, when she argued that you can't have defamation by implication of a public figure, so on and so forth. So it is, yes, very likely that the First Amendment is still going to show up in her appellant's brief, but it's not the type of thing that she's identifying here in this particular document, because this is just identifying the ruling that got wrong, not the reason for why the ruling is supposedly wrong. Johnny's assignments of error. Big contrast from what we see as the shotgun approach from Amber. We see a very targeted, directed approach from Team Johnny. Very straightforward, just 3, and not only just 3, but 3 that are kind of all related to each other, all having to do with essentially the viability of suing Johnny Depp for statements that Adam Waldman made to the Daily Mail. And so, yeah, there's a variety of kind of different challenges packed into that. Arguing that he's not an independent contractor is related to the argument that the jury was not correctly instructed then when they weren't basically asked to find and given information to kind of evaluate whether Adam Waldman was an independent contractor or whether he was an employee. Likewise, he is raising an evidentiary argument as well, which, of course, as you know, I consider one of the weaker arguments. But again, it's related to these other assignments of error that he's making, because he's basically saying you didn't have the context for these statements as a whole. Part of the argument that he's making is that the evidence is insufficient to show actual malice. And so the context in which Adam Waldman made those statements and in which they were published in the Daily Mail could very well go to that. So, yeah, I don't typically favor raising evidentiary issues unless they're pretty, rock solid in terms of, clear error by the court, and unless they're, plainly impactful on the outcome. But in this particular case, I think it is really close enough to meeting that standard because it is so related to the much stronger legal errors that he's assigning that essentially the requirements to attribute Adam Waldman's allegedly defamatory statements to Johnny Depp have not been satisfied. So once again, I am not going to go into the merits of any of these assignments of error at this time. I'm going to wait until the parties have filed their briefs. In part, that's just in fairness because I don't want to be creating straw man arguments that aren't what they intend to bring. So I'll wait and judge the merits of their arguments on the arguments that they actually choose to make. But I will point out that the first 3 assignments of error that Amber Heard has brought are exactly the ones that I suggested in my last video, are the ones that an appeal attorney would be suggesting you should be looking at these particular rulings. These were the rulings, the very first ruling that was made to keep the action in Virginia, the ruling that the UK judgment does not preclude a trial in Virginia, and the ruling that basically Johnny Depp's allegations were legally sufficient as a matter of law to justify having a trial on them in the first place, that they weren't opinion or otherwise not actionable. Those were pure legal rulings. So yeah, those are among the stronger ones that she has to work with. Obviously raising a whole bunch of evidentiary issues, which by and large are going to be weak. Rejecting a proposed jury instruction. This is sometimes a good one. Jury instructions can be very viable appeal arguments because if the jury doesn't have the correct law in order to be able to make their decision, then you've got a very strong argument that, yeah, that affected the outcome. If the jury doesn't know it should be applying a different standard, then a jury who applied the correct standard could very well reach a different outcome, again, depending on the facts. Incidentally, I mean, when it comes to actual malice, I do think that's going to be a challenge for Amber. It's very hard, from my perspective, for her to argue that the lies were not malicious just once you get to the point of establishing that they were lies. I mean, if the jury clears that hurdle, then, you know, she was there during the marriage. She knows whether or not this stuff happened before, you know, she decided to blare it out in the public arena. So again, yeah, it's a legal issue, can be a very strong one. Under the particular circumstances of this case, though, she may have a challenge convincing the court that the jury would have a different perspective on her mental state, even if, you know, whatever error she's arguing there was in the instructions was corrected. And then the rest of the assignments of error, again, these are legal rulings. These are dealing with the post-trial motions that she brought. Her argument that just legally speaking, certain things should or should not have happened. So those are, you know, by and large, comparatively anyway, stronger arguments than the arguments she's making about the evidence. So if I'm not going to go through all these arguments on the merits, then I'm afraid what that means, folks, is you don't get an opinion yet on who's going to win this thing. Does she have any type of a chance? Does Johnny have any type of a chance? If you've been listening to me on this case, or, you know, reading what I've had to say about it on Twitter for, you know, a long time, you probably already have a good idea of what I think the likelihood of success is. But again, I want to give them the full benefit of the doubt, the opportunity to present their arguments before, you know, I take too strong a position on what I think is going to happen here. But having said that, just from the perspective of strategy and where we're at right now, Johnny Depp clearly has the better legal strategy for his appeal. He's got targeted errors, distinct issues. He is not raising a shotgun approach or trying to, you know, complain about any and every little thing that went against him during the trial. And there were a lot of rulings that went against Johnny at trial. Certainly my perspective was that generally, when in doubt, Judge Azcarate ruled in favor of Amber. We certainly saw in the motions in limine, for example, dealing with evidentiary issues, a lot of rulings that went against Johnny. But he is not out here throwing all of those up as part of some argument that therefore he needs to have a new trial. So a very distinct and observable difference in strategies from Team Johnny to take this much more just a thoughtful approach of prioritizing what he wants to say. He's going to have the ability to flesh it out and make a strong argument a lot better than Amber is going to have if she is going to try to raise 16 different issues and, you know, argue them with any more depth than a puddle. As of today, the briefs are due on November the 2nd, so coming right up. It is still possible that those could be extended if they want to, if they ask the court, if the court gives them additional time. Would not, again, surprise me at all to see that happen. It is fairly commonplace in appeals. So we will see. But of course, I will be keeping an eye out. And once we get the briefs and get those arguments and can really sink our teeth into what they are saying went wrong here and why, and what law they are relying on to support their positions, then we're going to have a lot of fun taking these arguments apart and looking at who is going to win and why. So I hope you will join me there.